characteristics that you describe in this case. I'm just wondering, one question, was there an allegation of abuse made by this mother in that Israeli Supreme Court case that allowed her to relocate back to Germany, or was it completely based on her happiness? And then I would wonder how that was assessed. And you said there were psychologists who conducted a custody evaluation, and that's what Dr. Karicki and I do. But and again, anyone can create or fabricate allegations. But was there any evidence of anything that the father had done that had been abusive? Because from what you described, the mother's behavior is highly questionable in terms of her empathy and best interest of her son, of this child. And I agree with your conclusions. I'm puzzled by why the Supreme Court allowed her to move, and I understand your objection to it as well, but I'm wondering if there was anything compelling about her case that made the Supreme Court decide a decision which was highly unlikely, I think, in this country. I don't know if it would be highly unlikely, but my guess is that we hope to move toward your conclusion rather than the decision made by the Supreme Court in that case. So it's a complex question, but I guess first, were there other allegations, and two, what was the psychologist's role in assessing the difference between keeping the child in Israel versus the effect that that would have on the child and the relationship between the father and the child if the child moved to Germany?
Thank you for this question. I like your question very much because in your question you assume that it could not be that the court allowed the child to be removed to Germany. It just cannot be unless the father was a terrible father. And your intuition, to me, is healthy intuition. It's an intuition of a person who cares about the child, who's looking for the solution which is the child's best interest. But in fact, the father in this case, which I've mentioned, was an excellent father. He was very involved in raising the child. And the psychologist says that the child is very attached to the father, and that both parents function well. There's a question there, who functions better, like there are, it always arises in these kinds of questions, in these kind of cases, but I'm saying differently. If the father is abusive, then he should not be allowed to have contact with the child, even if the child is in Israel. So one question doesn't have to do with the other. And while the child was in Israel, the case took a very long time, over 5 years. So during these 5 years, the child went every week a couple of times to the father. So obviously we know that there was no abuse by the father. And in fact, the psychologist specifically says how involved the father is in the child's life and how important he is in the role he plays. The child in that case had certain psychological problems and adjustment difficulties, and all of that, switching countries, switching languages. I don't need to tell you how difficult it was for the child, and these were some of the arguments which led the psychologist to say that the child's best interest was to stay in Israel.
Was it also addressed that the mother was being alienated by removing the child to begin with to Germany? Was that ever kind of brought up in the court that you know of?
Yes,
exactly. Her behavior is very questionable.
Yes, this actually affected the psychologist's view, because the psychologist at first thought, well, maybe it wouldn't be so bad if the child would go to Germany, but after the psychologist realized what had happened, and that the mother abducted the child and did not allow the father to have any contact with the child for all that time, which was about 7 months or something like that. So this affected the psychologist very much. But it did not affect the court. So the court took the child and gave the child to the abducting the mother and allowed the abducting mother to take the child back to Germany, where she would leave the child with the grandmother and fly by Lufthansa all over the world. Yes?
Quickly, the students in this class learned in the first family law course that presumptions about who a child is best raised by have changed over time. There have been all kinds of tests courts have implemented that a child of tender years should be with their mother, and then there's been some changes when it should be with their father, and then a child of this age should be with the mother. My first question is this: are we to understand that in this particular case there was a presumption that even though the father was involved, the child is better raised by the mother, number one? And if, irrespective of the answer to that question, is your solution to the problem creating some sort of rebuttable presumption that in every case, short of some compelling reason, children should remain where they've been, assuming there's been no problems?
Yeah. Well, in this specific case, the case began when the child was very young, probably a few months old. So in that time, the first ruling of the court was that the mother would be the primary caretaker. And that wasn't challenged later on when the child became older. So the court assumed that what was true when the child may have been 1 year old is still true when the child is 7 years old. And even though the father became more and more involved during these years, this did not lead the court to challenge that.
So there's no automatic preference for mothers. I mean, and I know some of this is culturally bound. You go to some countries and there is a presumption that mothers are presumed to be primary caregivers. In other countries, it's not. Everyone's at least on equal footing, at least theoretically. So the question, I guess, is, was this woman presumed, was she actually the primary caregiver at the time the litigation really took off? Or was that just the benefit she got by virtue of the operation of law in Israel?
Well, there is a very broad problem in Israel in respect to deciding who the primary caretaker should be. There's a very strong preference to in favor of mothers. Even in severe cases where the mother abused the children, they would still get custody over the child. There was a case in Israel where a mother used to bite her children. She got custody. There was a case of a mother who tried to commit suicide by opening the gas at home when the children were with her inside the house. She got custody of the children. So there's you opened a whole a whole can of worms. But I think the other question you touched is whether the fact that the primary parent wants to move should affect the fact that he or she is the primary parent. This, to me, is the fundamental question. So what are the stages? At the first stage, the court decided that parent A is the primary caretaker. And then at stage B, this parent A wants to relocate. And the court needs to decide whether the parent would remain the primary caretaker or whether they will change that. And I think, well, I've read in different American cases that different courts in different states have different approaches on that. But to me, courts need to remember that the fact that a certain parent was determined to be the primary caretaker before that parent wanted to relocate, and now the parent wants to relocate, should imply to the court that maybe this parent is not as good a parent as we thought, because this parent is willing to damage the child because they got a promotion in a different place. Or this parent is actually alienating the child and wants to separate the child from the other parent. So this calls for reconsideration. Yes?
I was wondering if you could speak to what you believe the effect of the advent of programs like Skype and video chatting. Do you think that that is certainly not a sufficiently mitigating factor, but do you think that that changes the balance at all in terms of parents relocating if there's a stipulation that, yes, I promise my child will video chat every day or certain things like that? Do you believe that that has any sort of bearing at all, or it's irrelevant?
Can I ask you a personal question?
Yes.
Are you a mother?
No.
Okay. So I would assume most mothers and most fathers would prefer to read a bedtime story to their child when they're sitting next to the child, and bath the child when they're physically next to the child in the bathroom, and go and see the child play football or dance, ballet when the child performs. These activities, to me, are what parents ought to do, and as frequent as possible. So yes, if there is forced separation, geographical separation between the parent and the child, what you've suggested helps a bit, but that's how I would call it. It helps a bit. It doesn't change the picture. Yes?
I'd like to give you a hypothetical, if I could, and then ask a couple of questions. Let's assume that mother is the primary residential parent, and mother is a physician, and Bobby is the only child of this marriage, and the parties are now divorced. Mother has lost her position at Cleveland Metro as that hospital ripped out a number of physicians, and despite her best efforts to find employment as a physician, going as far east as western Pennsylvania, as far to the west as southeastern Michigan, as far south as Cincinnati, she has been unable to even get an interview in the Midwest to continue her career in radiology. She has gone to Orlando, Florida, and she has an interview and has a job offer that will pay her more money than she was making in Cleveland for working only 3 days a week in Orlando. Then I'm going to give you two alternatives for father. Father is the coach of Bobby's Little League baseball team. Father spends approximately half his time with Bobby, goes to every parent-teacher conference, and has been a huge supporter of Bobby throughout his growing up. The other father sees Bobby once a month, telephones him irregularly, has not acknowledged Bobby's birthday for the last 3 years, does not see him on holidays. Is there a different outcome in these two cases? Or stated another way, is the quality and character of the relationship of the non-residential parent with the child a factor that you would see as being relevant in the determination of the relocation case?
Wow. Okay, that's an excellent question. I think that it's difficult to determine what the solution should be in every specific case, like your question demonstrates very well. But I would say the following. First, let's open the options when we're considering how to resolve these conflicts. And by opening the options, if the mother could work in Orlando 3 days a week, why shouldn't she commute? For example, that's one option I would consider. Leave the child where he is and let the mother commute. This is something that I would expect the court to consider. And another thing that I think should be taken into consideration is the the second example which you gave, with the father who is completely uninvolved, I would challenge this father. I would ask this father, you know what? You don't want the child to go to Florida or whatever? Would you be willing to be the primary caretaker? And I think many fathers in this situation would say, no way. I'm not involved anyway. I don't want to become involved. So they would let the child go away because they wouldn't want that. So I think we need to challenge the basic premise, which is that the child goes with the mother. This, to me, is not obvious. This is something that we need to challenge all the time. But more importantly, I think that from my perspective, as a legal academic, as someone who tries to design laws which would function well, I look at the options and I say, I want this mother, which you spoke about, to try her best to find a job nearby. And if I will design a law which would allow her to go and to Florida and take the child with her to Florida, then she may not even look for a job in Cleveland, and it's very difficult for me as a legal assistant to check whether she had checked all the options in Cleveland. So if we say that according to the law, if the law which we designed allows her to go away, we're sending a message to all these potential mothers. Don't even look at, not necessarily mothers and fathers, to all the residential parents. Don't even try. Say that you try, but actually look for a job as furthest as you can from the other parent. And in the literature, which discusses the best interest of the child in many contexts, there needs some scholars have addressed this issue, and that is the difference between the best interest of the specific child and the best interest of children as a whole. And to me, this needs to be weighed once against the other. Maybe this, in one specific case, maybe we would make a bad decision, but we would send out a message which would help children as a whole in the United States or in the entire world to maintain relationship with both parents if the law would say that the parent could not move. And, you know, it's not black and white. For example, I'm going back to the case which I discussed earlier with the German stewardess. That is an amazing case because obviously for her it was more convenient that the child would live in Germany, but she was a stewardess. Stewardess fly for a living. So, I mean, for her, the inconvenience of having the child in Israel wasn't extreme, whereas the inconvenience for, I'm not talking about even this specific child, which the inconvenience for him being in Germany is enormous. I'm talking about the inconvenience of children as a whole, the inconvenience for them by the fact that we allow this specific mother to take the child to Germany. The inconvenience to children as a whole is much greater, to my view. Yes?
In a previous hypothetical, we thought about relationship between a parent and a child. Do you consider the parents' relationships to each other? I mean, what if it's a very bitter, horrible separation? They can't agree on anything. They can't work together on anything. Is this still the best case for the child?
Absolutely. I think that the message needs to be sent out that parents are allowed to hate each other. They're allowed to break up in bitter divorces. It's not good when it happens, but it's legal and it's allowed and it's understandable. But what they're not allowed is to tear the child away from the other parent, even when the divorces are bitter divorces. This is the message that I want to send out, that parents are allowed to be very angry on the other parent, but they're not allowed to damage the relationship with the child with the other parent.
One last point. First of all, your English is amazing. The second language, for you to be speaking English as well, is just very impressive. I've learned Hebrew for years, and I could never give a talk mother decides that she's going to move to Tzfat, and the father lives in Jerusalem, and it's a 3-hour distance between cities. I mean, doesn't in some ways that promote people making their own decisions or taking risks? Say, well, you know what, I hate this guy. Let me see if I can get a job in Haifa instead of in Jerusalem or in Tel Aviv where we lived before. And are those cases handled with any, I mean, I assume if the case in Germany was handled the way it was, I would wonder what ramifications it would have on internal moves within the country.
I think it's a very interesting point, which highlights that the discussion here is not necessarily about Hague, it's not necessarily about immigration, it's about relocation. Relocation in the sense of moving even from one city to another, changes which could affect dramatically the relationship of the non-primary caretaker with the child. Because if they live just 2 hours away, so the child could not come back from school to that parent on a daily basis. You're absolutely right in that. There are different judgments in Israel in that context. There's no clear ruling, but I think the strong message which was sent out, unfortunately, by the Supreme Court, was that mothers who want to damage the relationship of the child with the other parent, they have a very easy way of doing that. In fact, a recent case which was given in Israel involved a couple who got divorced, and in their divorce agreement, they had a term which said that neither parents could move. They lived in Jerusalem, and the divorce agreement said that neither parents could move over 30 kilometers radius from Jerusalem. And that agreement was approved by the court. And a while later, the mother applied that she wants to move a tiny little bit further than 30 kilometers outside of Jerusalem, Colombia. And the court allowed it. The court allowed it, even though in the divorce agreement it was said that no parent would be allowed to move over 30 kilometers, which to me, is so sad. Yes?
If the non-residential parent is the first to relocate, doesn't that become fair game for the residential parent? If they decide, and what's the burden upon the residential parent to maintain the child's status quo, or if they relocate, to relocate closer to the non-residential parent?
Right. Well, if the non-residential parent is the one who moves, personally, I have a problem with that as a person, not as a lawyer, because I think by the fact that the non-residential parent moves away, he's showing that he doesn't care, he or she doesn't care enough about the child. So it's something I dislike very much. But I think that as lawyers, we can't force parents to have a relationship with the children, even though we may want to, but we can't. But of course, if the non-residential parent moves away, so that the residential parent doesn't have to stay put, yeah, that's what I would say.
Thank you very much. Let's take a break.